Hi, my name is Ann Bennett. I'm a partner here at Beresford Booth with the Family Law Department, and I am going to talk today about committed intimate relationships, which begs the question, what is a committed intimate relationship? And a committed intimate relationship, or CIR is what I'll be calling them, is a relationship in which both parties cohabit with knowledge that a lawful marriage between them does not exist. So this probably applies to many people listening to this. You are likely in a dating relationship with somebody. Perhaps you've decided to move in together. Maybe you decide that you'll get married in the future. Maybe you decide marriage isn't for you, but you're in an intimate relationship, you're cohabitating, and you know that you are not married. And I have cited below, Connell v. Francisco is going to be frequently referenced, mainly because a committed intimate relationship is something created out of the judiciary. So these are the cases that cite the most relevant issues pertaining to committed intimate relationships. Now, why does that matter? So, Washington courts recognize that two individuals in a CIR may have an interest in property acquired during the relationship. So, following the termination of that relationship, courts may equitably divide the property in a manner similar to a marriage dissolution proceedings. So, that is basically meant to say that you might, just as in the previous example, decide to move in with your partner. There may be a conscious decision not to marry each other for whatever reason, but you may live together for 10, 20, 30 years without being married. Did you acquire assets together? Probably. Did you acquire debts together? Probably. Did you have a family? Very well, maybe. And so, if everything was in the name of one of those parties and not the other, would it be fair to simply break up and leave the party who didn't have anything titled in their name without anything that was acquired during that relationship? No, it would. That's not a fair resolution. Is it fair if it's a 2-year relationship and that happens? Probably. But that's why it matters. Now, how can you prove that you are in a committed, intimate relationship, not just a dating relationship in which you've decided to move in together? That is not a CIR. Just because you're dating, just because you've moved in together, that is not what a CIR is. And I'm citing again Connell, which established the non-exclusive factors for courts to consider when determining whether parties do have a committed intimate relationship. Those 5 factors are continuity of cohabitation, duration of the relationship, the purpose of the relationship, the pooling of resources and services for joint projects, and the intent of the parties. So those are all factors that the court must look at and weigh and view evidence for in order to determine whether or not a committed intimate relationship does exist. Now, with respect to the 5 factors, those are all statements, great, but what do they mean? So, continuity of cohabitation, is there a specific time frame in which you must live together or be continuously living together? There's no answer to that. But what's important for the court to determine is to show that these parties lived continuously without periods of separation or sporadic cohabitation. So, if you decided to move in together and then that wasn't beneficial to the relationship, so one of you moved in with a parent, but you wanted to stay romantically involved, you're not continuously cohabitating. Even situations in which one of the parties may have a job opportunity, so they've moved kind of long distance and you've decided to have a long distance relationship. Uh, Again, also not, that's also not continuously cohabitating. So the longer the cohabitation period, the more favorable this factor is toward finding a CIR. And the point being that it's a stable cohabitating relationship. You're stable cohabitating together. With respect to duration of a relationship, I would say the question that we get asked most frequently is how long does our relationship have to be to qualify as a committed intimate relationship? And the answer to that is nobody knows. It's up to the judge. The important thing is to provide evidence as to the length of the dating relationship. So a long-term relationship isn't a threshold requirement. Duration is a significant factor, but there's also subjectivity in terms of what long-term means. Is 5 years a long-term marriage? Is 10 years a long-term relationship rather? And it's honestly typically up to the judge that's making this determination. But the longer the duration of the dating relationship, the more favorable the factor will be towards finding a CIR. So if you've been together for 5 years, and during that 5 year period, you engaged in family planning, you've pooled a bunch of resources, you've met and then moved in together almost immediately, and you've been cohabitating for that period of time. Could you have a CIR? Absolutely. But unless you agree that you have a CIR, a judge will ultimately make that determination and may find that you did or did not. But the longer it is, the more likely it is that this factor would be met. The purpose of the relationship. Now, there must be evidence provided that the purpose of the relationship is for companionship, mutual love and support, possibly to create a family, but it must be more than just a relationship of convenience. And so, what that means is, let's say you were in a dating relationship with somebody and your partner's lease is ending, and they say, "Oh, listen, I just lost my job and my lease is ending. Can I move into your apartment?" And yes, okay, that's fine. Um, that's that's convenience purposes. In no instance did either party say, "I really love you. I think we should take it to the next step. Let's move in together." It was born out of necessity. Now, if both of those things are true, I love you, I want to move in together. Also, my lease is ending and I don't have a job, then that goes towards the purpose being towards that companionship, mutual love, and support, even though it was also convenient, the timing. So, this is evidence that will be weighed by the court to make a determination as to whether this factor is met. But emotional, financial support, and intimacy are all important elements of the purpose of the relationship to be able to find that a CIR does exist. The pooling of resources. So this is also often a point of contention with parties that are involved in committed intimate relationships or dating relationships because some parties may be of a disadvantaged position, or you might be in a committed intimate relationship in which you've decided to have a child with the other party, but you're not married. And in order to care for the child and kind of preserve that family unit, one of the partners has decided, to be a stay-at-home parent, to take care of the household. So what judges often look at is whether there were joint bank accounts, commingled expenses, did you purchase large assets together, did you jointly contribute to savings or retirement accounts together. But in those disadvantaged situations, if one party doesn't have the ability to do that, the court can consider the time and effort contributed more so than just financial resources. It's a lot easier for a judge to make this determination if you do have joint bank accounts or if you did engage in long-term planning, commingling savings or planning on retirement or for retirement together. But that's not the crux of everything. So it's important to provide evidence that time and effort were contributed to the benefit of the community, which is to the benefit of that family unit. So that's typically what pooling resources means. The intent of the parties, there must be a mutual intent of the parties to be in a committed intimate relationship. So if one party says, I love you, I'd like to move in together and maybe draft an agreement about us being in this relationship and what that means, and the other party says, I'm not into commitment. Yeah, we can move in together, but I don't want to do any of that. You don't have mutual intent there. So it's very important that each party is kind of on the same page with respect to this. So, a party engaging in open relationship, for example, doesn't show necessarily that commitment to be in that stable long-term relationship. It's important that both parties have the intent to have this committed, intimate relationship, a stable relationship in which the parties cohabit. Now, what does that mean if you can provide all of the evidence and the court says, okay, you do have a committed, intimate relationship? If a trial court determines that you do have a CIR, and it has terminated, the court can equitably divide property that you have acquired during that CIR, just like they would in a marriage dissolution. There is a rebuttable presumption that property acquired during that CIR belongs to both parties and is subject to equitable, not equal, but equitable, meaning fair distribution. Uh, and when I say during a CIR, the reason I underline that is because you also have to allege when your committed intimate relationship began. And that is somewhat subjective in that did you cohabit? Sure. When did you start planning long-term things together? Did you start family planning? The date that you moved in together is not necessarily the date that a committed intimate relationship began. You can certainly allege that is when it began, but you do have to provide evidence and support that claim as to when it began and also when it terminated. And then the property you've acquired with your partner during that period of time becomes quasi-community property subject to that equitable distribution, which is also subjective because fair does not mean equal. So you would have to provide evidence as to why you should receive 50%, 40%, 60%. So what financial positions will you be in after this? How long was your relationship? If it was a 30-year relationship that just didn't result in marriage, but you've had kids together, one person's been a stay-at-home parent all that time, and they've never worked, it's probably not fair to do a 50-50 distribution. It's probably fair to award that disadvantaged partner more of the community asset than the other, but everything is fact specific. And it's also important to note that the courts do look to RCW 2609, which is the dissolution statute, for guidance as to how to divide assets and debts. But it is an equitable doctrine that's created by the judiciary. It is not created by statute. So you can use a statute for guidance, but you can't say this is what the statute requires because there is no statute. So that just kind of a short rundown of what committed intimate relationships are. I do encourage anyone that thinks they might be in a committed intimate relationship to discuss with their partner what they think and what they think they might be entitled to. Because the worst thing to happen is that you're engaged in even a 7 to 8 year relationship with somebody, and you simply don't know what happens if that relationship dissolves. Uh, we have a marriage and dissolution statute, which guides people that are getting divorced, but that's not the same. And it could be very unfair that you're in a relationship and you acquired things together, and then at the end of the day, you don't know what you're entitled to. There's nothing written down, and your name's not on anything. So I encourage everyone to discuss these things with their partners. And certainly, if you have any questions, I have provided my contact information here. We do CIR agreements and things of that nature, dissolutions of CIRs as well. So please feel free to reach out if you do have questions or think this might apply to you. Thank you and goodbye.